On behalf of ASPTC and ODOT, we would like to actually welcome you all, to this webinar. Both the topic and the presenter. This is a very interesting topic, and I think our presenter does not need any introduction, but I will still go ahead and introduce, Professor Dr. Doug Gransberg. So as you know, I think I'm going to do a little bit of logistic issues. So those of you, please, keep yourself muted. If you have any questions, I think we'll be holding the questions till end. And then I think we should have enough time, to answer any questions that you may have. So please hold your questions and we'll ask at the end. Also, if you need PDH, I think, as you know, that the PDH is given based on the attendance. So make sure that you're logged in, from your, whatever account that you used. So because that is something that we have to use in order to issue PDH. It's a free PDH. I think that something it is difficult to beat that. So we really appreciate. And also one more thing is that the presentation would be posted on the ASPTC website as a PDF. So you should be able to review it or maybe share it with other people that may not be here. So, last point is that if you would like to actually see, some, similar webinar in future, we are not going to ask you for money, but just we ask you to actually email me and or Dr. Molina, for any topic that you want to see presented in future. I think this is a great opportunity. One positive aspect of COVID is, this type of activities that we can actually all participate, remotely and still get benefit and gain knowledge. So again, we want to thank you all. And I also am thankful to, Michael for, his assistance with the logistic of this event, and also with Alan Leon, one of our undergraduate students, for his help with the flyer and also the distribution of the flyer. So with that, I think we would like to actually listen from, Dr. Doug Gransberg. The topic is 5 deadly myths of managing geotechnical risks. I'm a geotechnical engineer myself, registered professional engineer, but this topic is really, really interesting because we always, have to deal with risk. Anything that we do comes with risk, unfortunately, or, we do not have any way to avoid it. So Dr. Gransberg is the president of Gransberg and Associates in Norman. Prior to actually, he has really, all sorts of experience. He's also emeritus professor of construction science. And he also worked, for the U.S. Corps of Engineers, and he earned his PhD from University of Colorado. And he got his, baccalaureate degree from Oregon State. Doug has really very diverse set of experience. Anytime I talk to him, and I have known him for quite some time, we have been, friends for a long time, I still learn every time I talk to him. So with that, Doug, the floor is yours, and we look forward to listening to you.
Thank you very much, Musharraf. Give me a minute while I share my screen. And then I got to find my pointer here somewhere. Oh, I think I have to do that. Yeah, there we go. All right. And one last thing is I've got to get my chat shown somewhere. Okay. Thank you very much. This is a subject that's near and dear to my own personal heart. What I'm going to be doing is kind of giving you the benefit of a number of experiences that we've had. I'm going to be talking mostly about the legal side. So I want you to know that I am not a lawyer. I am an engineer. I got my PE in 1978. And my company spends an awful lot of time working with various agencies, consultants, and contractors doing risk analysis, alternative delivery, and other types of services. Okay, so there we go. So let's talk about what the issue is here. You know, it's all about whether or not you really have X-ray vision and ESP. So just some numbers that came out of a recent study about subsurface conditions. You know, 7% of the cost of cost overruns in the transportation industry that are attributed to differing site conditions. And overall, that brings it up to about 1% of an agency's total budget. So if we can deal with differing site condition risk, we can probably save some money. But this is the key point that came out of here. Increasing the amount of subsurface investigation has no impact on the number of change orders, claims, and cost overruns. So, you know, while we get a much better design process, the way we handle the communication of what we found in those investigations is the reason that we have a lot of issues with this. And you know, one of the key things, and we're doing it here right now, is trying to build increased communication and training on this topic to be able to understand how to better handle this. So in a nutshell, geotechnical risk isn't a technical issue. Okay, I mean, the good Lord laid down the geology. There it is. None of us, until we dig a hole, know exactly what's beneath the surface. What's really the issue is recognizing, not denying the fact that we need to quantify the uncertainty that's associated with this, because uncertainty impacts both competition and prices. The more uncertain conditions are, the higher the prices are probably going to be, and perhaps the lower the competition, which then also causes prices to go up. You can't change uncertainty. I mean, we can't change the rocks that are going to have to be excavated by writing a contract clause. They're still going to be there. It's just, when do we hit them and how much impact do they have? Unfortunately, most engineers, and I'm speaking primarily to engineers here, not necessarily to our brothers and sisters in the legal profession. Most engineers think you can, that we can just put it in there. And we learn that at places like University of Oklahoma in our engineering design classes, where we can say, well, if you don't know something, make an assumption. And so what we assume is that we can write a contract clause and that will cover the risk. What actually happens is that these risk shedding contract clauses really just furnish the starting point for a battle that's going to occur if we run into a differing site condition during construction. Background on where this information came: I was PI on principal investigator on NCHRP project 2444. We produced this particular report number 884, which, by the way, is available for free download at the Transportation Research Board's website. It was focused on design build because that's really where we have kind of the biggest question, is how much geotechnical investigation does the owner do before asking the design builder to commit to a firm fixed price and then finish the geotechnical subsurface investigations. But really what we found applies to almost any kind of project. One of my partners on this particular project is an eminent lawyer, Mike Loulakis. Mike also is a geotechnical engineer. In fact, was a tunnel designer before he became a lawyer. So Mike is pretty well attuned to this. And what Mike did was to get into the legal aspects. And that's really what I'm going to be talking to you about here. You know, the only difference between design build and a traditional low bid, design bid build low bid project is whether or not the owner will do all the subsurface investigations before contract award, or if they'll outsource that to be done by the design build contractor after award. So kind of benchmarking the state of the practice of what we're doing in the US today. Mike's finding is that the bulk of the US construction case law with regard to differing site conditions demonstrates the owners very rarely win a claim. In fact, about the only times they do win is when the contractor did not submit timely notification in accordance with the contract. So it's very hard to shed this risk. However, owners seem to think they can, and they put exculpatory language in things like, you know, the contractor, quote unquote, will assume responsibility for all unknown conditions. I've seen that in the current contracts. And industry recognizes that there is going to be this risk shedding bias. And as a result, they feel the geotechnical risk is much higher than the folks writing the solicitations. What that drives them to do is to put in contingencies. I worked on the Cooper River Bridge project in South Carolina with Flatiron. I was on the contractor side, and the CEO of Flatiron said, yeah, you know, risk is easy to manage. You just throw money at it and make it go away. And that's exactly what we did. You'd be surprised at how much contingency went into that project just because the documents had exculpatory clauses throughout. So that basically causes the cost of a project to go up. You get nothing for free in construction. And then if we do run into something and it causes a problem, the claim gets made anyway, regardless about what's been written in the contract. And then if the owner loses that dispute, if it goes to litigation, as well as arbitration, and you know, arbitration panels are typically lawyers, and they tend to rely on past case law. So they're very much like the courts in that the owner always starts a differing site conditions claim from a position of weakness. And the final result is the one I kind of want to highlight here. You know, it's a pay me now and pay me later type of situation when we decide to shed the geotechnical risk rather than manage the geotechnical risk. So you're paying them now because you're getting contingencies buried in the bid price. You know, by the way, if they don't have any differing site conditions, you're still paying that. I mean, those contingencies are built into those unit prices. And if we run into one and have to go to court, we get to pay a second time. And so the idea here is, what I'm going to try to do is, there are 5 what I call the deadly myths that pervade our industry. And you know, I started with the Corps of Engineers in 1974 and was told that some of these myths were actually true, that I could rely on these things. And so that's kind of the purpose here, is to try to bring these up, and then to also show you some possible remedies so that we can better mitigate the subsurface uncertainty that we can't run away from. So geotechnical risk management myth number 1 is that the way the owner or the designer perceives the risk is going to be exactly the same way as the construction contractor, because it's the same project site, same contract. Seems reasonable. You look at that quote I've got there, you know, for an effective, efficient construction project, we have to have common perceptions of contractual risk. Okay, so that those things are shared, so that myth would be true. However, the fact is, it's a myth. The contractors don't perceive the geotechnical risks as in the same magnitude as owners do, and it's markedly different. And in fact, this came out of our research project. We identified 27 geotechnical risk factors based on what we'd seen And then we went ahead and went out and got 60 plus DOT geotechnical engineers. And on the other side, 60 plus design build contractors and their geotechnical engineers to rate each one of those things on how often do they occur. In other words, what's the probability that you'll run into the water table that's higher than you anticipated. And if it does happen, how big is the impact? And so we used a algorithm called the importance index as a way of kind of ranking these things. And what you can see is that the owner's risk perception and the industry risk perceptions were completely offset. Industry saw the risks as much higher than what the owner did. Now, when we kind of ran that rabbit down to the hole as to why, it's because the owners thought they could shed the risk, that they were pushing it over here. And I guess that kind of makes sense because the contractors feel like the risk is being shed to them. And so it becomes a higher risk to them. In fact, we only had one common risk that was the same. And so you've got to recognize that perceptions are important. And so potential remedy, first is and this was the key finding from our report, is we've got to find a way to achieve that common perception of risk. So aligning these things with the owner or the contractor or the design build team in some form or fashion is one way to do it. There are potential contractual mechanisms that permit a way to early align that. Now, some of these are, I'll just give you some examples. Here in Oklahoma, ODOT doesn't use design build, progressive design build, or construction manager general contractor, but in all those cases, we actually hire the contractor during the design process and allow them to participate in what the final, make substantive input to what the final design solution is. Ohio uses multiple notices to proceed, with the first one being for getting out and doing the utility potholing and digging test trenches to find out where rock really is in the excavation, those kinds of things, so that if there is going to be a differing site condition, it's found immediately or as soon as practical, and you sort that thing out so it doesn't impact the entire project. So that mitigates the overall cost. Virginia has a clause where they give, based on the project, usually about 90 days to validate the scope. And then if after 90 days is over, then they don't accept any differing site condition claims. That doesn't mean they don't end up in court if they run into one, but this has greatly reduced the number of issues that they've had to deal with outside of the agency. And then last but not least, there are other contract mechanisms for addressing geotechnical risk. Washington State DOT actually puts a dollar value in the contract, and it says that the contractors are responsible for the first X dollars, let's just throw a number out there, $100,000 of differing site conditions, unforeseen utilities, whatever it is that's below the ground, and that the state then is liable above that. Talking to the chief engineer out there when we were doing this thing, she attributed that one clause to reducing the number of nickel and dime claims and change orders, requests for change orders that she's gotten or that they get on their normal projects, just because the contractors are putting it in their bid and they know they've got money to cover that one issue. Myth number 2, requiring the contractor to make a site visit, familiarize itself with the existing conditions, and include that knowledge in its bid effectively insulates the owner from change conditions claims. The answer to that is clearly no. Now, this is something that, there are three doctrines, especially in construction law, that cover the responsibility for the quality of the construction documents. The first one is called the Spearin Doctrine. This goes back all the way to a Supreme Court decision in, I believe it was 1908, it might have been 1918. But essentially what it says is that the owner supplies an implied warranty on the buildability of the design documents. So if there is something that causes it to have to be built differently, then that breaches that warranty. And if that's not good enough, we have what's called good faith and fair dealing doctrine. And and what that basically says is that we regardless of how adversarial we are, we still have to play fair. And if the owner or the designer can't find the condition from the surface, it's unfair to try to impose that responsibility on the contractor. And then last but not least, the case law is pretty clear that the owner always is presumed to have superior knowledge of the project site because it's like on their right of way. Whether or not they could find the fact that there was a contaminated soil or something like that is immaterial. They probably owned the land when it was contaminated. So those three things make it very difficult to avoid that particular risk. And so remedies for this, there are a number of agencies that are building a statewide geotechnical database of all the projects that they have so that designers and owners can actually look at them during planning and early design, before they actually initiate a lot of the subsurface investigations. The other thing is to get out there and just go ahead and sample to make sure that you identify where there might be contaminated material. Right-of-way acquisition process. Property owners know if their property used to be a Texaco station and there's liable to be a couple of tanks lurking about underneath the pavement that need to be remediated. Having an actual differing site condition clause, which elaborates on how the risk of differing site conditions are going to be shared between the owner and the contractor, is an important one. In a federally funded project, you're required to have a differing site conditions clause, except if it's a design build project. Now, why that's not in there, I don't know, but that's the way the federal highway rules came out. And then here's about looking forward to it and not trying to deny it. And, if we think there might be contaminated materials out there, then just ask for unit prices in a form that if there isn't any, then you don't pay for any remediation. But by putting it out there and asking for a price if required, what you're doing is putting the contractor on notice to look for this, and also, more importantly, to reduce the impact to the overall project if they bump into it. Same thing with selected geotechnical pay items. One of my clients in a utility company in California, we routinely put in unit prices for rock excavation and dewatering into there, in case it needs to be done. We've already got that price settled. It's the contractor knows it's coming, and it doesn't turn into this big surprise that causes a lot of emotions. Myth number 3, this is probably the worst one of the bunch, is that if you put something in there and it's not exactly correct, then you're going to get a claim. Well, at the end of the day, if you're asking for pricing, the contractors have to have a basis from which to bid the subsurface scope of work, for these very things. And in the case law, and again, I'm citing Mike's work, it time and time again, if the owner failed to disclose known geotechnical information or known contaminated material or utilities, anything that's below the ground, then they lost the claim. So, at the end of the day, by taking this differing site conditions clause and crafting it in a way that's going to be fair to both sides, we can mitigate that. Now, let me just talk you real quickly through one of the landmark cases that had to do with differing site condition clauses. You know, that in this particular federal case here, Foster versus the U.S., you know, the courts said that the purpose of the clause is to take some of the gamble on subsurface conditions out of the bidding. I'm not sure some of this stuff is exactly correct, but at the end of the day, by having that, knowing what's going to happen if we do run into something different, the contingencies and those other things can be reduced. Now, the benefit to the owner is more accurate bidding, you know, and not having to pay for stuff that doesn't eventuate. I mean, you know, at the end of the day, if you run into something that's different from the basis that the contractor would have to use based on the information furnished to them by the owner, then you're gonna have, you know, you're gonna have to pay for that. If you knew it was there, then you would have had to pay for it anyway. So this myth of not putting it in there because it's going to generate a claim is totally unwarranted. So remedies, you know, give them everything you've got. You know, you know, put in a pay item for post-award exploration to identify actual conditions if indeed you feel like that's a big risk. You know, things for like potholing for utilities, digging trenches to find out where the rock is and to locate the water table so that we can at least know where our issues are going to be before we're delaying the entire project. And then last but not least, you know, at negotiating the interpretation of the data that was furnished in the bid, plus any newly found information so that we now have a definition of what a differing site condition is. Number 4, and this is the exculpatory clause myth. So if I give everything I know about a particular site out in my bidding documents, but then I take my boring logs, geotechnical reports, whatever else we're furnishing, and note that these are for information only or for bidding purposes only, accuracy is not guaranteed, that then allows us to not be held responsible for the information that are on those documents. You know, the bottom line is we get back to that good faith and fair dealing doctrine. You know, what else do the bidders have to rely on to be able to do their bids? If you're not guaranteeing the accuracy, what can they do to make it more accurate? So again, that's a one that was covered by a landmark case, I think, that is really very clear. Again, this is another federal case, but this is often referred to in differing site conditions case law. But I'll just read the underlying part there. The effect of an actual representation is to make the statement of the government binding upon it, despite exculpatory clauses which do not guarantee the accuracy of a description. So saying this is what we think is there, but if it isn't, it's not our fault, is probably not going to stand up in court. It then goes on to say that, you know, even though there's not an express statement, in other words, that that this information is warranted by the government, its effect in this case was to create a description of the site upon which the plaintiff, in this case the contractor, had a right to rely, and by which it was misled. So I mean, this is how the court sees these things, not necessarily how we feel about it. And so at the end of the day, you'll notice that this exculpatory clauses on this particular case, you know, can't absolve the owner from these, you know, broad sweeping things, you know, that you know, because and they cited another previous case, you know, that did not relieve the defendant of liability for change conditions as the broad language thereof would have seemed to indicate. So, we're at the end of the day, we spend a lot of time going over words and trying to come up with ways to not assume liability for things that we believe are risky. You've got to remember the intent of what you write may be perceived differently by the reader. And if this thing goes outside of your control into arbitration, litigation, whatever, in litigation, you're going to have to convince a jury. I helped the Oregon DOT on a massive differing site condition claim where it was, if you had a PhD in geotechnical engineering, Dr. Zaman would have been able to understand the difference in a half a degree of phi angle. But the average Burger King chef who's going to be sitting on the jury, all they are going to be able to understand is, was it the same or was it different? And the contractor was able to prove it was different. And they lost in court. End of story. So you have that issue as well. I mean, we can make a point and we can be technically correct, but can we express that technical thing to the satisfaction of somebody that's going to find one way or another? So potential remedies, again, invest in and maintain a database. Virginia has got one of these going. It's in a GIS platform and it's available to designers, planners at very early stages of project development. So they're not making assumptions. They've got whatever Virginia knows. And by the way, that database, I think, is also being populated by municipalities as well, as far as to, what does the ground look like around these transportation facilities, so that they don't have to make assumptions. And it forces them to have to look at it and say, oh my goodness, we might have to do some rock excavation here, and the water table's 6 inches below the top of the ground. So as we're picking the alignment for this project, maybe we should find a better way. That next one is just common sense. You need to train people to know that you can't just put in, this is for bidding purposes only, and then we'll fight about it, because you will fight about it and you will probably lose. Last but not least, one of the things that can be done, and this gets back to the aligning perceptions that I got to in one of the earlier slides. Sit down at the pre-con meeting before anybody's invested any huge amounts of money in equipment and excavation and those kind of things, and just discuss what the interpretation of the subsurface information is going to be. We often in our differing site conditions clause will use the term materially different than. Well, that's something that we can fight about. Is a 12.5-inch rock materially different than a 12-inch rock? Depends. If you're depends on the situation. And so why not talk about that before it becomes an issue? And say, all right, what we're talking about materially different needs to be 50% greater or whatever. I'm not going to give any recommendations here. What I am going to recommend is that don't just fall back on that materially different than, and when it turns out that they ran into a 13-inch cobble and you say, well, 1 inch is not materially different than 12 inches, recognize that we've now are going to make a number of folks over in the legal profession rich, because they're going to get the opportunity to be paid to try to sort through something that a couple of good engineers could have sat down on a project site, talked through what the implications of an inch larger cobble would, and come up with a mutually agreeable solution. So last but not least, the fifth myth, by qualifying, and this is often the term is used, weasel words, okay? Qualifying a given product, construction method, or type of equipment as the recommended approach removes the owner's liability if it doesn't work. You got to recognize what you've created here is an ambiguity, because recommended is ambiguous in a contract. You know, a contract lists requirements. Okay, is it just a suggestion, or do they have to do it that way? And what happens if the contractor chooses not to follow the recommended method? Can the owner disapprove the alternative approach? And again, what we're trying to do is just avoid these fights. And so here's ambiguity doctrine, which is the last doctrine I'm going to kind of talk about, but I think it's a real key thing. An ambiguity in law is when there are two reasonable contract interpretations. I once was on an arbitration panel in Texas, where we were arbitrating essentially whether or not an inch and a half of hot mix was materially different than 41.5 inches of asphaltic material that was actually encountered. Well, that doesn't seem like it would be any hard one to do. However, the attorney said, well, the contractor gave us a unit price per square yard, and a square yard is a square yard. It doesn't have a third dimension, so therefore it's on them. What we were looking at was an ambiguity. There was a detail that showed a drawing that had an inch and a half of ASB, which you would assume is asphalt stabilized base, and a note below that would lead you to believe that there would be it was actually an ASTM thing for granular base, so no asphaltic material. And on top of it was the hot mix, which everybody agreed it was an inch and a half thick. So what would the contractor bid on? Well, he actually read the ASTM thing and said there's gravel underneath there. So it turned out there wasn't. It was asphalt stabilized base. And by the way, they didn't define asphalt ASB either. So again, another little thing. So what happens if you run into an ambiguity? You get into this I can't pronounce the Latin word. I'll let you read it. But as determined who bears the risk. And usually it's construed against its author, but it's a 4-part test. Who wrote the specifications? So if they were done by the owner, was the language used susceptible to more than one interpretation? Okay, do I believe the picture with the letters ASB, or do I believe the note with an ASTM reference to granular base course? It could be either. Both were reasonable. And was this intention of having two different interpretations accidental or unintentional? Okay, so if these have been deliberately weaseled up and that can be proved, then this test fails. And then last but not least, the contractor has to have actually and reasonably construed that specification in accordance with one of its meanings in which the language was acceptable or susceptible. So if all those things are tested, then the ambiguity is construed against the owner, and the owner loses the claim. Remedy: just drop the word recommended or preferred, or all those qualification things. Don't put it in there. I mean, if you want it, specify it prescriptively. If this is the only way you're going to accept compaction tests, then this is it. Don't just say the recommended method would be to set up test pads and do a minimum of these rollers and this and that. And last but not least, if there are more than one technically acceptable option, let the contractor submit the one it bid and then just review it as a submittal. So how do we manage these things? Well, we need to not rely on the contract's verbiage. We need to proactively mitigate these things. We got to recognize that we don't know what's under the ground. The contractor doesn't know what's under the ground. we won't know until the contractor digs the hole. And so therefore it might be different. And how are we going to deal with it when we find out that it does? Even with the most thorough site investigations, it's where you poke the hole. If we did the borings in areas that had no rock, then we're not going to find rock. I just finished a project we were working for MnDOT up in near Duluth, and every sample they took had no contaminated material in it. And then, of course, when the contractor started excavation and they tested the material per the contract, it was contaminated. So suddenly we had a differing site condition that required remediation of that. And so the whole idea here is recognize this is probably going to happen and deal with it. Be an engineer. Don't try to be the lawyer that you. There are a number of tools. I'm going to show you one that we used in the Panama Canal expansion project, which was probably the most tricky geotechnical project I've ever been involved with. But what we tried to do was to use visualization. Now, part of that was because we were speaking a number of different languages down there. Chinese was another one that was being spoken. But the idea is to sit down and look at in this case, a geotechnical baseline report and convert it to a risk rating. And so you can see what we've done here is this is all the kind of things that the folks that are paid to be geotechnical engineers come up with. What we do is we interpret that and say, okay, along this alignment, we've got zones that are high risk, we are zones that are low risk, and then we have zones that are going to be something in between high and low. What that then allows us to do is to bring that in and do an analysis. In this case, this is a fairly sophisticated analysis using Monte Carlo simulations of where might the contractor not be able to achieve the productions that it put in its bid and put the owner subject to a differing site condition claim because the risks were high. And so all this is this is a linear schedule for those of you that are used to doing CPM, but it's showing two activities, a grout curtain and then the embankment that sits on top of the grout curtain. And these are the productions that the contractor would hit. And where you see a red circle, we have areas that even though this is not a very risky part, have some delays that are production related. So what you can see is the Monte Carlo results, and for those of you who would like to learn a little more about linear scheduling, I always try to remind people that CPM was not invented until 1968. In fact, my father, who was an engineer with the Montana Highway Department, saw me putting a linear scheduling lecture together for my class at OU and said, "Oh, so you guys are still using that? That's great. That really worked out good." He used that to build Interstate 90 in Montana before 1968. In fact, I don't think Montana probably went to CPM until after I was out of college in 74. But the idea is there are other ways to do it. And this particular one is a really great way to forensically visualize the impact of a different site condition. So what you do in this particular example I'm going to show you is we basically just took 4 major activities, geotechnical activities that were different varying amount of risk. The real issues, the big issue was the grout curtain. We had to pump grout until it refused into a friable or a cracked shale foundation and create a cutoff wall. There were other areas where special geotechnical treatments had to go down. There were these filter blankets that regulated the flow through the embankment, and then there was this impervious clay core. And just to give you kind of a feel for what you're doing when you're working in that particular environment, you've got 2 seasons. You've got the rainy season, you've got the not so rainy season. And so if you're doing structural embankment with a a cohesive soil like clay, water content is a big risk that we have to deal with. So the amount of rain we get is an issue, and we can have a change site condition by having an abnormal amount of rain. So we've got to keep track of that. So this is actually an as-built linear schedule that was taken from all the daily work reports, and it just showed where the contractor actually worked and how long they were in that area. Now the blue is that grout curtain, and that was the source of our differing site condition, the main differing site condition claim that was on this one. This is the plan view, the elevation view, excuse me, of the profile for, orange being the top of the embankment, and then this was the existing profile. And you can see as we worked our way along this, in particular this area, they spent an awful lot of time pumping grout in there. In fact, well over a year just to fill that up. Whereas in other areas, they only spent a couple of months to get that happen. And what this allows you to do is look at it, and if there's a white spot, that means they're not working. So we start getting into concurrent delays. So if the contractor doesn't show up for work, then that's not the owner's fault, and that time period in here certainly is not part of the differing site condition geotechnically. You can also see these areas here. I've got the yellow ones. When we looked at those blank areas, what we found out was that there was supposed to be instrumentation. Piezometers were putting in the clay core to measure pore pressures. When they got to that point where they needed to be installed, the contractor had forgot to order them, and had a long order ship time. You can see where this little orange dot is. Here's where they got installed, and they went in and buried them there. So concurrent delay, not the owner's fault. There were also other issues that came up. Quality control issues. When we have non-compliance reports, you didn't meet compaction, you didn't do whatever. Again, those are delays. It's work that's having to be redone. That's accordance with the contract and not part of that differing site condition claim. We also had an area here that basically showed that even though they, it took a lot longer to get the grout in there, they didn't do much after they got the grout in. So we have to dive deeper into this area and find out why weren't they producing. Same thing up there. Now, this is if I combine the other visualization tool with it, you can see what I've got. If you look at where the risky area was, that coincides exactly with where we had the excessive amount of grout being used. But this was part of the geotechnical baseline report that was part of the bidding documents. So would you expect to have to put more grout in here than you would in an area here? And the answer is yes. So that should have been in the bid price, at least some of it. And what was interesting is when we took the schedule, this was the as approved schedule for the grouting sequence. They'd start at this end, end up at this end. And by the way, this is the time scale. But what actually happened was they started in the middle, which is where they needed to, because that was the riskiest part. However, because of this issue, that's one of the reasons they didn't get going on the embankment on top of the grout. So again, I'm not assigning responsibility. All I'm doing is looking at the records. And by the way, we used the contractor's daily work reports because we felt they would be more accurate than the owner, just because the owner's inspectors were always limited. They weren't always there. And then I talked about the rain. This was another way to set up a system where we're going to capture the information and just to deal with it. These bars here were the actual rainfall amounts. in precipitation per month. The average that would be expected in the rainy season was only exceeded in this 1 month here. So again, how do we allocate the impact of this differing site condition to that? Well, what we did is we took a look at their construction placement for the core with regard to the time frame, and you'll notice during the rainy season here they didn't meet their planned production. However, in the rainy season here, they actually exceeded their planned production. So again, without trying to point too many fingers, what we ended up with is the ability to come to a common understanding as to what events happened and how concurrent delays contributed, rather than getting into it that, well, we had this big problem, so all the delays in the project are now on the table. So getting to the end here, it's the summary. When we're talking about subsurface conditions, the best way to do it is to start digging as soon as practical. Figure out what the in situ conditions are, and then figure out a way to retire that risk as early as possible. Best way to minimize the cost of that risk when it does get realized is to make sure that all parties of the contract have the same perception about what the risks are going to be, and that we implement some risk sharing approach like a design differing site conditions clause. And then recognizing it's going to be there, we want to set up the construction administration system to capture the information that's going to be required to allow us to quantify the cost, schedule, and impact of differing site conditions when they do occur. Bottom line is this, by trying to run away from or shed the subsurface risk, what we end up doing is paying for those risks that were not realized. If we got through the whole project without a differing site conditions claim, and we had all those myths all built into our construction documents, we paid for the contractor's contingency that went unused, and that didn't add any value to the project. So my recommendations, I thought this was a very interesting quote we got from one of the contractors. I think something that those of you that are owners and consultants really ought to think about. This guy was in Ohio. He says, the real risk is not the cost of the extra work to remedy the differing site condition. It's whether or not I have to sue the owner to get paid. And so he puts contingencies in just for the fact that they might have to sue the owner if they run into something. And so this is my attempt at a little bit of humor here. You're an engineer, practice engineering, okay? Don't try to practice law. Those of you that don't have a military background probably won't recognize the term latrine lawyer, but when I was in the Army, that was the private that advised all the other troublemakers on how to get around and get over the law and not get punished or whatever it was. Well, when we start putting these weasel word things and exculpatory clauses and trying to convince ourselves we can run away from geotechnical risk, we become latrine lawyers. And so the big takeaway, you can't be risk-free. Okay, design and construction of infrastructure projects is hard. Nothing ever goes according to plan. So if you can't be risk-free, be risk-aware. Take that engineering degree that you got and practice engineering with it. Recognize where the risks are and mitigate them. And so with that, I will open it up to any questions that there may be. To do so, I would just ask you to maybe raise your hand.
So just let me make a couple of remarks, Doug. First of all, this is wonderful. We really, really appreciate you taking time to actually bring, as you said, I really like your last statement, the punchline that there cannot be risk-free situation. So it's better to accept it and be prepared for it rather than sort of pretend that there would not be any risk. I would also like to mention that last year, Doug actually, along with Neil Grantsberg, offered a short course, one-day short course in this area, the risk. And I think we had about primarily ODOT people, about 50 or so people. And I think we are planning to, and as a part of that short course, there were some recommendations as to if the audience wanted to see, more short courses in future. And there are a bunch of, I think you can spend a lot of your time, Doug, addressing those, having these short courses, but we're going to have at least one short course in this area this year. So please, keep an eye, and I think we'll try to include, of course, ODOT is our preferred audience because they provide money, but also we'll try to include others in the short course as well. The second thing I also want to mention is that we offer, this is, just give me a second. Dave, I need to call you back. So the other thing is that we offer, internships, summer internships. So that announcement would be coming. We call Transportation Regional Internship Program. So we already have your email, so please keep an eye. SPTC provides part of the cost for internship, so it is really good it's a win-win situation. So if the student actually works, for your company, you could actually retain that if the student decides to join you later on. But of course, there is no guarantee that the student would do. So with that, actually, I'm going to open and one more thing, that you're going to get your PDH if you indicated one, and if you did not indicate but you still want to get it, just send an email. Otherwise, your PDH will be processed based on your attendance. And please, if you want to see any topic that you have in mind, just suggest as to what topic you would like to see presented in future. With that, I'm going to open the floor up for questions. And I see that Jerome Estes, yeah, please go ahead, unmute yourself and ask your question.
Yes, thank you. This is just a basic question, and I am a roadway designer. I was just referred to this course, so I am not a geotechnical expert, but just from a higher level, seems like when you go participate in some activity, not speaking of engineering, but just some activity that involves risk out here in Colorado, a lot of times you're required to sign a waiver. And most anybody knows that a good lawyer can get around a waiver, yet businesses have folks sign the waivers anyways. And my whole point is there any truth to the concept that if you're providing information to a contractor that's not at the same level of detail or supposed reliability as compared to actual parts of the contract package, is there not still some wisdom behind including some of this latrine law that's maybe approved by the AG's office with the information you're providing, understanding that you're not completely isolating or insulating yourself from risks, but that you are trying to say, okay, this information we're providing is not at the same level of reliability as the rest of the contract. Is there any wisdom in doing that?
None whatsoever, even though it would seem to be intuitively obvious. I mean, what Mike did, he literally looked at every court case that had a differing site condition claim on it. And the trends were just really clear. I mean, what I brought up was the contractor has to have a basis to give you its bid price. I mean, that's one of the fundamental things that the court recognizes. And if all they have is what you give them, then their bid price is presumed to be reflective of what the level of information they had. If you get into design build, things get a little fuzzier because you're going to ask them to flesh out the subsurface investigations as part of the design process before we start construction. However, if you're asking them for a firm fixed price before they have the opportunity to go forth and do their own borings, have their own geotechnical engineer interpret the lab results, the way the court looks at that is they, you asked for a firm fixed price, and they had to, their basis for giving you that number is based on the information that you provided. And so, even though, and that's where I get to this idea, that we feel as engineers, and particularly the folks in the consulting industry, have this sense that they don't want to assume liability that they can't control. Well, at the end of the day, subsurface liability is not controllable before award by any of the three legs of the contract: the owner, the designer, or the contractor. And so the case law is just overwhelmingly leaning in the area that the owner is going to have to, the owner can't shed that risk because, nobody has ESP and X-ray vision. And so, however, that being said, if you move into things like progressive design build or construction manager at risk, construction manager general contractor, particularly in CMGC or CMAR, the contractor is the guy that owns the backhoe. So why would we just have the consultant go out and do borings? If there's an area we're worried about, the contractor's on board. Let them do that as a pre-construction service. Go out and pothole, find where the utilities are in this one intersection, and we'll design around where the actual utilities are. Go dig a hole here because there might, and tell us where the water table is, because we're going to negotiate the price, okay, rather than bid it. And so it's a function of when is the contractor at risk for the contract amount for construction that drives this kind of a decision.
Wonderful. So I think we have another question, Doug, from Matt Bejensen. Matt, please go ahead.
Yep, thank you. First off, this was great. I thought this was a really, really useful presentation. So thank you for this.
Thank you.
I'm coming from a number of years being with a P3 developer, where differing site conditions is always being a big arguing point between us and our design builder and the owner, and kind of being in the middle of it all. But I've always had the same the same perspective that you mentioned about why pass on the risk. You're going to pay for it whether it happens or not. And I've always wondered why owners don't just hold on to this risk more and deal with differing site conditions as they arise. Are you seeing any trends across the U.S. with owners that are starting to realize that and take back ownership of that risk?
Yes, I think as we get into alternative project delivery, it's design bid build has its own baggage. When you got to pick the guy that made the biggest mistake on his cost estimate, a good contractor has to come up with a number lower than that to win. You've got some issues that have to be dealt with. But when we get into the more collaborative ones like P3, design build, design bid build, integrated project delivery, for instance, although that I don't think is going to be a big deal at least in transportation. I work a lot in New Zealand and Australia when we get into alliance. What we're finding is that if the owners will take advantage of the ability to negotiate the risk profile, generally the contractor, the owner, the concessionaire, the developer, whoever it is they're negotiating with, returns the favor, because what, we know it's going to happen. And if it doesn't, we're lucky. And if we've shared the risk and don't realize it, at least, when we're negotiating a guaranteed maximum price or whatever the terminology that's there, we can negotiate the contingencies. We can negotiate allowances. We can negotiate the terms and conditions. Ohio DOT, when they did a tunnel project, actually it was design build, had the contractor do his own GBR. And then they sat down and they eliminated the word materially different than, and just said, here it is. If you run into a cobble that's bigger than 12 inches, then you get paid for it. And the contractor that was, that was on there, was one of the guys that I interviewed. He said he cut his contingency by 25%, just because that they eliminated that uncertainty about what's the interpretation of materially different than. So, as you know, Matt, if you're coming from the developer's perspective, risk isn't free, and you get what you pay for in this industry.
Doug, would you stop sharing? That way we can actually bring the other people on the screen as well, and then
absolutely.
Yeah, thank you. And any other questions? And I also have some questions, but I would let other people ask questions first. Well, my question is that, yeah, okay. So I see a hands on from Preston. Preston, please go ahead. Please unmute yourself. Please unmute yourself and then ask question. Michael, would you help unmute? Preston?
I can only ask to unmute. They'll need to unmute themselves, but I don't see their hand up unless they put it
I don't
down.
either.
Okay. Yeah, anyway. So my question, I think for, in this is a very, so you talked about 5 myths, 1 through 5. So in this order, 1 through 5, Doug, which one is most problematic in terms of, let's say, litigation? Which myth do you see has been primarily responsible for litigations?
The exculpatory clauses, the putting for bidding purposes only, putting something that the contractor assumes responsibility for all, geotechnical, different, those things that qualify and try to shed the risks with the stroke of a pen.
So in this, think that is it the education, that educating the owner is the primary thing?
And consultants and lawyers.
How do we change the situation going forward? Right?
Training. Come to the short course. The questions are there. It was there in 1974 when I started with the Corps of Engineers, and was told this. Oh yeah, we're just going to put this clause in here, and we don't have to worry about that anymore. And so when you're out there on the project site, and by the way, I was a construction guy. You just tell the contractor, read your contract. Here it is. It says you took that, and I will say that there are those that make a business decision not to do that. But I would also say that in many cases, the business decision is made because their contingency was high enough that they're still going to make money without having to take you to court. So.
Right. Well, anyone else has any other questions for for Doug? So please, feel free to ask any questions you have. Otherwise, we are going to sort of conclude this webinar. Anyone has any questions? And also in our, within SPTC, Dr. Pittenger is kind of, is also very much trained in this area. So this is, Dominic, you want to make any comments?
Oh, hi, Doug. It
Hi,
is-
Dominique.
It is a very important and timely topic. And I think it's one, like Doug said, it's not going away. So.
No. So you're right, Dominic. So if we know that it's not going to go away, then it is better to embrace it. No one wants to be penalized, but if we realize that this is going to happen, then at least we'll be prepared, right? So hopefully that will happen. So again, we want to thank you all, for taking your time, to attend this wonderful, very practical thing, Doug, that you talked about today. And as I said, that there will be another workshop. So watch for an announcement and watch for the trip announcement, also the internship announcement. And if you are interested in any topic, please suggest a topic and a potential speaker, or if you want to present, I think we just simply want to know. We're increasing this frequency kind of, would like to actually have maybe, we used to have 4 to 6, but now we're trying to get maybe 6 to 8 per year. So this way, at least when it's a good way, and free PDH. I'm a professional engineer myself. When I fill out my form, I say, what did I do? Why can I get 1 hour? So this is, so you will get your PDH. And again, thank you all. And please give a virtual applaud to Dr. Doug Gransberg. Hopefully one of these days we'll have in person. So
and let me say, if you have any questions, please contact me. I'll be happy to talk to you. I mean,
absolutely.
I love hearing the various issues that people come up with. So
absolutely. Paul, thank you again very much. With this sort of concludes our webinar, for today, and we look forward to seeing you again. Thank you.
Okay. Bye-bye.